This is Barry Zalma on insurance. Every construction contract will invariably contain a condition requiring the people involved in the contract to maintain insurance. Insurers who insure the liability of contractors will usually include in their policy a warranty that compels the general contractor to obtain proof that all of its subcontractors are insured. In an important case, North American Capacity Insurance Company versus Claremont Liability Insurance Company, a 2009 decision of the California Court of Appeals, that enforced such an agreement and issued a warning to all general contractors who do not comply with similar warranties that they may be eliminating their own coverage. In this case, the warranty or condition required that the insured follow its general business practice to get hold harmless agreements and certificates of insurance from its independent contractors. The insured failed to do so and tried to enforce the contracts, claiming unsuccessfully that it did not need to comply with the warranty. The warranty provided that coverage afforded by the policy shall not apply to operations performed by independent contractors unless they were insured and unless the named insured has received a written agreement from each and every independent contractor or subcontractor holding the insured harmless from all liabilities incurred by the independent contractor, and has obtained certificates of insurance from each and every independent contractor indicating that the independent contractor will maintain similar coverage as provided by this policy that was issued to the general contractor. The insurance industry also uses similar warranties that require that each independent contractor name the general contractor, the owner, and/or the developer as additional insureds. And warranties are like conditions, except they are a serious promise by the insured that are always, by definition, material to the contract, and failure to fulfill such a serious promise can and usually will deprive the named insured, the general contractor, of all of his coverage. So if the general contractor does not have in its possession certificates of insurance from every independent contractor or subcontractor at the time the work begins and throughout the construction, the insurance is unenforceable. Every general contractor, developer, and subcontractor that uses subcontractors must be certain to obtain the certificates required by similar policy terms. Failure to do so can be devastating. The Court of Appeal, in reaching its decision, applied settled doctrines with regard to the interpretation of an insurance policy. Such interpretation in California is a question of law that the Court of Appeal can review as if it were the trial court. Notwithstanding that insurance policies have special features, they are still contracts to which ordinary rules of contractual interpretation apply. The Court of Appeals concluded that the fundamental objective of contractual interpretation is to give effect to the mutual intention of the parties. If possible, the court will determine that intent solely from a contract's written provisions. The clear and explicit meaning of the contractual provisions interpreted in their ordinary and popular sense governs judicial interpretation, unless the words are used by the parties in a technical sense or a special meaning is given to them by usage or by contractual terminology. If a layperson would ascribe to the contract language a meaning that is not ambiguous, the court will always apply that meaning. Reviewing the trial court's factual findings for substantial evidence, the appellate court starts with the presumption that the record contains evidence to uphold every finding of fact, and the person appealing has the burden to demonstrate there is no substantial evidence to support the findings under attack. For example, in Scottsdale versus Essex Insurance Company, a 2002 decision of the California Court of Appeal, the Court of Appeal enforced an endorsement substantially similar to the issue in the Claremont case, finding the special condition endorsement to be unambiguous and therefore enforceable. In Scottsdale, the insured, a licensed architect and general contractor, built a large single-family residence purchased by the Operas. The final inspection was completed in April of 1991, and the Operas purchased the house in October of 1991. Within months, water began to infiltrate the home, and several years later, sewage spilled in and under the home due to a failed pump, leading to buildup of mold. The Operas filed a claim against the insured. The insured, in turn, referred the claim to his insurers. Essex Insurance Company provided comprehensive general liability insurance to the architect from February 15, 1991 to March 21, 1993, and Scottsdale provided such information from 93 to 94. Essex denied the claim, but Scottsdale accepted the insured's tender of defense, settled with the Operas, and then sought equitable contribution from Essex. The Essex policy of insurance contained a special condition endorsement, similar to the endorsement in other cases, where the insured was required to obtain certificates of insurance from all subcontractors, hold harmless agreements from all subcontractors indemnifying the insured against all losses for work performed, and they must ensure that it was named as an additional insured on all subcontractors' general liability policies. The appellate court in Scottsdale held that the endorsement did not render the policy illusory, because the parties exchanged promises that represented legal obligations. If the person insured satisfied the condition, that is, required his subcontractors to obtain insurance naming him as an additional insured, then Essex was required to participate with those insurers in defending or indemnifying the insured. As so interpreted, the court held that the Essex policy was not illusory as the insured had claimed. The appellate court also held that the endorsement was not analogous to a disfavored escape clause, because the endorsement was merely a condition precedent to coverage, not a clause that eliminated coverage in the presence of other insurance. Nor did the appellate court find the endorsement ambiguous. The requirements were clearly set forth, and the endorsement plainly states that meeting those requirements is a condition of coverage. The insured clearly was required as a condition of coverage to obtain certificates of insurance from all subcontractors, to obtain hold harmless agreements from subcontractors against all loss for the work performed, and to make certain the insured was named as an additional insured on all subcontractors' liability policies. Moreover, the court found the contractor's warranty endorsements to be conspicuous, plain, and clear. The lesson taught is that if a policy provision contains conspicuous references to forms applicable to all coverage on the pages listing the premium and limits of insurance, and announces that there is a forms list attached on the first page directly under the statement, quote, "In return for the payment of premium, and subject to the terms of this policy, we agree with you to provide the insurance as stated in the policy," then a court will conclude, as did the Claremont Court, that the language of the endorsements establishes a condition to coverage rather than an exclusion from coverage. A condition precedent refers to an act, condition, or event that must occur before the insurance contract becomes effective or binding on the parties. In general, conditions never confer nor exclude coverage for a particular risk, but rather impose certain duties on the insured in order to obtain the coverage provided by the policy. When there is a clear and explicit meaning in a policy warranty added by endorsement as used in the ordinary and popular sense by a layperson, it will establish a precondition of coverage. Every person involved in construction contracts must ascertain if their insurance policy requires certificates and/or additional insured endorsements, and must make sure that their construction contract complies with the insurance requirements, or they will find they have no insurance at all because they have failed to fulfill the condition they promised to fulfill when they acquired the policy and paid the premium. As a foundation supports a structure, the construction contract supports the parties to the construction. A sound contract is necessary for a hassle-free construction project. Whether the parties use standardized contracts modified using standard modification documents, standardized documents modified by the parties to meet the needs of the particular product, or a specially drawn contract written by competent counsel, it is imperative that the parties agree on what duties and obligations exist as to each other. Once agreement is reached, the project should proceed without problems or animosity. If there are problems, a well-crafted contract will make it possible to resolve them by using the methods included in the contract documents. The construction contract, entered into between competent and professional builders, architects, developers, owners, and contractors, should also make it possible to avoid the construction defect claim or suit. But if defects do arise, that same contract should facilitate resolution of the claim in a quick and amicable fashion. Every party to a construction contract must make sure that the contract is prepared thoroughly and clearly in language that all parties understand and agree to. The contract should project the interests of the signatories. The parties to the contract should recognize the interest of each of the other parties to the contract and be willing to negotiate the terms and conditions of the contract so that it takes care of the interests of the drafter and all of the signers of the contract, and each party to the construction contract should attempt to protect his or her interests through the term of the project without taking unfair advantage of other parties. If a contract is written as a contract of adhesion, all ambiguities will be interpreted against the drafter of the contract unless it is so obvious that the other parties are on inquiry notice to obtain clarification of the ambiguous language before signing the contract. If a contract is ambiguous and cannot be clarified, then it should not be signed. And every construction contract should deal with the needs to protect the parties by effective insurance and make certain that all of the insurance contracts, warranties, and conditions are met not only by the owner and general contractor, but every contractor, every party to the construction project. This video was adapted from my book, Construction Defects and Insurance, Volume 1, which is available as both a Kindle book and as a paperback from Amazon.com. If you found this video to be useful or interesting to you or your colleagues, please pass it on. It's free. And please also click on the like button and the Rumble button on my YouTube and Rumble accounts. And please also subscribe to my YouTube account, my Rumble account, my blog, and my Substack publications so that you can be advised of future blog postings and future videos. Thank you for your attention.